Okay, so this is part 3 of the residential purchase and sale agreement. I want to go over some things that give me stress. I've had arguments. I've years ago during short sales because I just wanted to get them done. Frequently, and it's not just me, many of us realtors. There might have been a refrigerator in the garage. It might have had a sign on it that said it doesn't transfer, but the buyers are like, "Oh, I wanted that," and you wind up saying, "Oh, okay, here's $1,500 of my realtor commissions just to get this thing closed." So, my first advice is if it's not staying, you may want to move it out. If it's not staying, certainly put a sign on it. If it's not staying, make sure you put it in here in writing. Now, I'm going to tell you another odd thing is that on high-end properties, and I've sold a few, some of those expensive ranges or cooktops with the ovens are on wheels. And every buyer in the world would think that if they walk into a kitchen and they see a nice range there, they're like, "Wow, I'm looking forward to buying this house with that nice range in there." Maybe it's a Viking or one of the other top ones. And I don't even like to tell you what the rules are on this one. So I'm going to consult ChatGPT here, but I'll just say if you're excluding, if it's a nice range, I'd say definitely put it in here as excluded or included because it's an issue. It has become an issue. So let me just say that oddly, if a range has wheels and is not anchored, even if it's heavy and appears built in, it is likely not a fixture under California law. That means it does not automatically transfer under the RPA unless it's clearly defined or physically affixed. So that's just one of the things why you'd want to work with experienced agents because they've come across these things over time. Now, this next section, you want to get those natural hazard disclosures reports out to the buyer as fast as possible. The buyer, you probably want to read them early on. Smoke alarms frequently come up where, those post-closing inspections and you run down Home Depot and you put a smoke alarm in the kitchen. These are questions: who pays, buyer, seller, or both? Who are the escrow holders? This is very important to a seller, I would think. You want to make sure the escrow holder is bonded, insured, you trust with the amount of money they're going to be dealing with. I really like the service I get at escrow companies that are not like, I can think of them. There's a famous one in PB. There's one in Carlsbad I use a lot. But I want to make sure that the big money is being held at like a Stewart or First American, one of those major publicly traded title companies aren't going to go away too easily. They're probably well insured because, I actually personally have had a problem where the escrow company disappeared with $70,000 of my money. And I had to go track them down. And basically I said, "Look, I'm an attorney. I'm going to recover against," this happened in Florida. I said, "I'm going to go to the state. I'm going to recover against your license or try. Even if I get 0, it's going to be down for fraud and you'll never work in real estate again." And all of a sudden I got my check. So I can imagine what the sums we're talking about now. This was 15 years ago. I don't think you should take escrow for granted. Title policies. I used to say each pay for their own. I don't see that in here as much as easily. I probably both each pay. HOA transfer fees. These sometimes can be a few $100s, $400, $600, $200. So, if you're a buyer, you might want the seller to pay for it. If there's a lot of competition, maybe you'll eat it. Private transfer fees is a very tricky one. If you're dealing with those, you probably want to talk to escrow, title, and your insurance. In fact, you always want to knock this out. This is a scary section. Home warranties, I don't see why a buyer wouldn't want those. I've collected on those personally for myself. We had problems with pipes in our walls, and they covered a decent amount of it. Not all of it, but a decent amount within the time period. These are the addenda. that I don't think too many sellers are worried about, but just know that if you're in probate, these are things really, you can read through them. Short sale addendum, those were popular a few years ago. I wonder if they'll be coming back very often. Sometimes buyers are going to do property exchanges, so seller intent. So you've got the forms for those. REO advisories, right? Short sale information advisories, probate advisories. That's good. And then you'll notice, because we were dealing with here's something. Most people don't realize that all properties are sold as is in California. It's just that it's as is, but buyers have a right to inspect and request repairs. But the seller doesn't have to agree, but then the buyer can cancel. I'll even read this. Unless otherwise agreed, the property shall be delivered as is in its present physical condition as of the date of acceptance, except in paragraph 9C, seller is not responsible for repairs. Seller written notice to remove the items within 3 days. Buyer, after delivering to seller written notice to remove the items. So this is just buyers advised to conduct investigations of the entire property in order to determine its present condition. Seller and agents may not be aware of all defects. Again, one of those clauses that kind of helps realtors not be responsible. We're dealing with, what if the seller's remaining after the close of escrow? If they're doing it, there are addendums for that. So 29 days is a lot easier to accomplish than more than 29 days. But there are different documents, contracts that can be brought in as part of this contract. Now, this is, if you're going to remove contingencies, and you probably want to, you're going to follow this procedure. But you can see that all the way up until the buyer and seller blocks, realtors aren't going to change these. They're not allowed to. As a seller, you might want to talk to your lawyer about Xing things out and changing them. But really, the big deals for realtors are getting these initials, right? Dealing with these addendums, the arbitration. Where are we at here? The liquidated damages, mediation of disputes. You're going to want balance here, symmetry. And then entity of buyers is really the first thing. Full name of buyer, full entity name, contractual identity. Buyer acknowledges receipt. The names of the legal authorized signers are buyer signatures. And now we've got a couple check boxes, counteroffer, entity of sellers, seller signatures. And I said in the first one, I don't think the buyer's agent wants to fill this out, or the buyer. If I'm an attorney, I'm going to let the sellers deal with this. I'm going to identify the property and be very careful about that. But I'm going to let the sellers fill that in. We're not parties to the agreement as brokers. There's a presentation of the offer thing, but there's no more. You don't see anything about buyer agent compensation in there. We already dealt with that in the previous video. But the listing agent's no longer guaranteeing anything there. And then we're back to other contracts, parts of the contract that we can discuss in the future. So if you want to find out more, go to winnerscheck.com. My motto is, before buying or selling real estate, winners check, winnerscheck.com. I'm a broker and attorney in California. There's two major takeaways. If you're a buyer's agent, you might want to use my form, or you might want to buy direct from the listing agent. You probably don't want to sign those buyer agent agreements where you have to agree to pay money ahead of time. I mean, that's something before you even get to writing this contract. You really want to be locked into a payment. What if there's multiple offers and the seller doesn't need to offer buyer compensation, but you have the money to buy that property and it's your top choice? And then secondly, as a listing agent, I would not do any of this. I wouldn't sign a listing agreement. I wouldn't sign a purchase and sale agreement without the seller to listing agent addendum that I created so that you remain in control of buyer agent compensation and you don't do it passively and just basically cost yourself 3%. All that's at winnerscheck.com. Thanks. My name's John McConnin. I'm a broker and attorney in California.